And welcome everybody to the After Brackeen Outcomes and Implications of the Supreme Court's decision upholding the Indian Child Welfare Act. This webinar is brought by the Indian Nations Gaming and Governance Program. The Boyd School of Law Indian Nations Gaming and Governance Program was established in 2020 thanks to a very generous gift from the San Manuel Band of Mission Indians. The program consists of specialized academic training for Juris Doctorate and Masters of Law students, as well as public programming, academic and policy research, conferences and symposiums that examine current issues in tribal gaming and governance, such as this one. The William S. Boyd School of Law wishes to acknowledge and honor the indigenous communities of this region and recognize that this webinar is taking place on the traditional homelands of the Nubi and Nuwu Southern Paiute people. Today, I'm joined by my colleagues of the Indian Nations Gaming and Governance Program, the San Manuel Band of Mission Indians Professor of Law, Addie Rolnick, and Distinguished Fellow Professor John Tsuda III. And my name is Danielle Finn. I am the Program Director of the Indian Nations Gaming and Governance Program and an Assistant Professor in Residence. So thank you all so much for taking time to be with us today and joining us. And I'm going to hand it off to my colleagues.
Good morning or good afternoon, depending on where you're joining us from. My name is Addie Rolnick. I am the San Manuel Band of Mission Indians Professor of Law here and Faculty Director of the Indian Nations Gaming and Governance Program. Some of you may have attended our webinar last November. We had many of the panelists that are joining us again today to look at the upcoming Brackeen case. And today, our job is to look back on it and consider its significance in a number of ways. So just as a bit of background, in the late 1800s, and I'm sure this is familiar to many of you, the federal government embarked on a program of assimilationist boarding schools. The goal of those schools was expressly to sever the ties between Native children and tribal communities and to turn the children into people that wouldn't be Indians anymore. The outcome of that would then be that the land was free for settlement. That program had corollaries in other settler nations. So Australia, New Zealand, and Canada all had expressly assimilationist residential boarding school programs. And those programs have been in the news over the past couple of years. So for those who don't have a background in this, may be familiar. That program was rejected as sort of an express assimilation program in 1934, but by the 1950s, the federal government had sort of turned its efforts to disperse and assimilate Native people away from tribal communities by doing it through handing them over to states in a number of ways. So that included a relocation program to move Native people to cities and handing over jurisdiction over a number of reservation communities to states, and also partnering with states to encourage state child welfare agencies to engage in promoting the adoption of Native children to white families. And so that's the historical context in which the Indian Child Welfare Act was enacted, or against which it was enacted in 1978. So in 1978, after learning about the massive number of Native children that had been displaced from their communities at the hands of state child welfare agencies, Congress enacted a law, and our panelists will talk about exactly what it did, but the Indian Child Welfare Act aims to stop that problem by acknowledging that the future of tribes is connected to the future of Native children and vice versa. So both depend on each other, and recognizing the rights of tribal communities to control outcomes for their children. And that law has remain the same. And as a legal scholar, I'll just say on the side, I think it's a very well-constructed, good law in a lot of ways. And in 1989, the Supreme Court heard the first challenge to the law in Mississippi Band of Choctaw Indians versus Holyfield, and it upheld the law and fairly strongly made statements acknowledging the link between the well-being of tribal children and tribal communities and why the law was important. Then the Supreme Court didn't hear anything about the law until 2013, when in Adoptive Couple versus Baby Girl, there was a challenge. It was actually sort of a far-reaching challenge to many aspects of the law, but the court ended up holding on fairly narrow grounds about a particular provision of the law and whether it applied to the family in question, and avoiding the question of a lot of the far-reaching challenges. And then in the years between that case and this year, there's been an active campaign in federal district courts and federal courts of appeals, but also in state courts to continue mounting challenges to the law in different ways, which culminated in the Brackeen decision over the summer. So everyone who works in this field was quite nervous about what might happen given the challenges, and the court did uphold the law. But what we want to do here is talk about exactly what the court did, what the court didn't do, and what it might mean for both children and Indian law in general. So I will pass it off to Professor Tsuda to introduce the panelists.
Thanks, Addie. Welcome, everybody. As Danielle introduced us earlier, my name is John Tsuda, and I'm a distinguished fellow here with the program and also an adjunct professor teaching Indian law with the law school. Really excited to have our distinguished group of panelists, and let me just introduce them very briefly so that we can get into the program. First off, we have with us Brooke Pinkham. My apologies, Brooke, if I hacked that up. Who's the staff director for the Center for American Indian Law and Policy at Seattle University School of Law. With us also is Catherine Fort, the director of clinics and director of the Indian Law Clinic at Michigan State University School of Law. We have Greg Ablovsky. Again, I apologize, Greg, if I have hacked that up a little bit. Marian Rice Kirkwood, professor of law at Stanford Law School. Also with us, we have Bethany Berger, the Wallace Stevens Professor of Law at UConn School of Law. And as practitioners, we have with us Alyssa Connolly, tribal attorney with the Stillaguamish Tribe of Indians, and Deborah Gee, chief counsel with the Office of Tribal Justice Administration with the Chickasaw Nation. Welcome, panelists. Thank you for spending the time with us, and look forward to hearing what you've got to say.
So our first question is, please tell us briefly, what is the Indian Child Welfare Act and how does it impact tribal child welfare systems and the practice of law in that area?
Sure, thanks. And also, Kate Fort here. I call myself a practitioner as well. I just want to be, for the record, I also practice and teach. So I would put that out there. In our work at the Indian Law Clinic, we represent tribes in complex ICWA litigation. I was lucky enough to work with Deborah Gee on a case. I do a lot of ICWA cases in appellate courts, both state and federal. The law, as Addie mentioned, right, is passed in 1978 and provides specific, as Justice Gorsuch said, preview guardrails on state usually child protective proceedings, require heightened burdens of proof, certain provisions requiring additional efforts made to keep an Indian family together, which we call active efforts, and also the testimony of a qualified expert witness before an Indian child can go into either foster care or have the parental rights terminated. In order to have an ICWA case, you have to have two things. You have to have an Indian child and you have to have a child custody proceeding. They're both defined in the law. An Indian child is a citizen of a tribe, or member is the language that the law uses, or a member of a tribe and eligible for membership and the biological child of a member. And a child custody proceeding seems very straightforward in the law, but gets really complicated really fast. But briefly, is a foster care proceeding, a termination of parental rights proceeding, a pre-adoptive placement, or an adoptive placement. But for the purposes of a foster care proceeding, we should acknowledge and understand that it applies to guardianships. It applies anytime a child is temporarily removed from their parent. The parent cannot have the child back upon demand, and the child is placed with a guardian, foster parent, or other placement. And so when that happens, and this is always in state court, which is why Brackeen's such a weird case when we start talking about it, because it actually was brought into federal court out of state court. State court judges are supposed to follow the requirements of ICWA, or we have a lot of Washington people on here, or the state law where states have adopted state ICWA laws. And we had a whole bunch of those happen in the last few months. Actually, I just made for Professor Berger, I just finished a footnote on something I need to get to her, just listing every state ICWA law so we know where they are, and there are far more than there were before Brackeen started. So that is, I do a whole semester covering that. That is 5 minutes on what ICWA is and where it applies.
I'd like a copy of that for Kate.
Soon enough, everyone will have it.
Great. Again, my name is Alyssa Connolly. I handle, for the Still tribe, I handle Indian child welfare matters both in the Still tribal court, other tribal courts, Washington state, and out-of-state courts, and I handle the trial and appellate matters. Luckily, haven't been too many of appellate matters, and I really agree with what Kate just said. It's nice that ICWA provides minimum federal requirements, and it's supposed to produce somewhat consistency throughout the United States, how to apply ICWA, theoretically. And I would have to say, and I can touch on this later, that post Brackeen, that seems to be better. And like Kate mentioned, that we have finally a lot more states adopting their own ICWAs, and it's nice here that we have our own WICWA, our Washington Indian Child Welfare Act, and it's nice because a lot of it's telling that a lot of the state practitioners, including the parents' councils, really utilize the active effort. And so my advice to fellow practitioners, future practitioners, is that we, as proponents of ICWA, we need to make sure that we are advancing arguments that don't diminish active efforts. And so whenever I have a parent advocate arguing, oh, they didn't meet active efforts, and maybe that's not in the best interest of my client, normally it is. But even if it's not, I can't help but smile, because I'm like, that needs to remain a high standard, and we need to be really careful about the arguments that we make and who we're supporting as well.
Well, thank you for that information. That's similar to what we're experiencing in Oklahoma. My name is Deborah G. I'm the Chief Counsel with the Chickasaw Nation Tribal Justice Administration. Just to put some of this work that we do into context, we have roughly over 75,000 Chickasaw citizens. We cover 13 counties in South Central Oklahoma. We have on our staff, our Chickasaw Nation Child Welfare Services staff, we have a total of 34 employees, and they cover our administrative functions, as well as our child protective services staff, permanency, and adoption staff. We have a main office in Ada, which is our headquarters of the Chickasaw Nation, with 3 satellite offices. We have 24 staff that are assigned to ICWA cases in Oklahoma and out of state. So we have quite a bit of work that our staff does with the Indian Child Welfare Act. We also, within our office, we serve as the juvenile prosecution team in the Chickasaw Nation District Court. So we handle juvenile deprived cases, juvenile delinquency cases. And then we also employ an ICWA legal counsel. So her role is to appear in state courts across the state, as well as making court appearances outside of Oklahoma. And she files the necessary motions to intervene, motions to transfer cases. She's made approximately 146 court appearances a year in 12 counties across the state. We also have a more recent ICWA court in Tulsa County that serves a major metropolitan area, and many recently recognized reservations are within that where that court sits. And she participates in about 8 out-of-state ICWA cases. As far as caseload, before the Brackeen decision, we have seen more of an increase in our tribal cases brought in the Chickasaw Nation District Court. We went from 14 to now we have 31 cases. ICWA cases in Oklahoma is about in the 80s, 81. And then the out-of-state cases, somewhere between 37 to now we have 48. So we are seeing, an increase in certain areas as far as our ICWA advocacy on behalf of our Chickasaw children.
Thank you. Before we move on to our next question, I just want to see if any of the other panelists want to add anything to this one.
All right, so next up for our panelists. I think we'd like to know well, first off, if you could briefly give us what the arguments were made by the various parties, and then what did the court actually decide?
So I have a little PowerPoint here that I was walked through how to share my screen. So here we go. I'm just going to give a high level, and then I believe Kate and Greg will really get into the weeds on a couple of the other arguments that were rejected by the court. Well, by the majority at least. It's here. Okay. Oops. Sorry, you guys. I do this. Okay. Got it. And I'm going to, oh no. Look, and you guys can just see everything right now, can't you? Okay. Home. All right, slideshow. What am I supposed to again?
Above the home link,
Right, the
Right.
one, right, okay. Okay, and then we go to display settings and swap. Good?
looks perfect. Thank you.
Great, thank you, everybody. So in short, the opinion came out on June 15, 2023. It was a 7-2 opinion. The dissenters were Justice Thomas, Justice Alito, the majority opinion written by Justice Barrett, a really tough concurrence written by Justice Gorsuch, and one, I wouldn't say describe it as touching, but by Justice Kavanaugh, the concurrence as well. And then our course dissenters wrote an opinion. So what did the court decide? In short, tribes won every issue, and there were 3 main principal issues, and each issue had its own sub arguments as well. I'm just touching on the main 3 though. But number 1 is that yes, Congress properly exercised its Article 1 authority to create ICWA. And the court drew on a couple different sources of the law, treaty clause, a trust relationship, but the main focus was on the Indian Commerce Clause. And the big takeaway for me that is the Supreme Court continued its trend on precedent that commerce doesn't mean trade activity here. It's more than that, and that's because Congress gets to engage in Indian regulating affairs with individual tribal members, not the tribe. The second main issue was that ICWA does not violate the 10th Amendment anti-commandeering principles. So here, what was really concerning as practitioners is that these were key protections of ICWA that were like active efforts, expert testimony, witness testimony, reporting requirements, and even the placement preferences. They're trying to say violated the 10th Amendment prohibition against commandeering, but the court the majority rejected that argument for two reasons. Second, they made the distinction between state courts and state agencies. But they said though that ICWA applies even-handedly to both private actors and the state government, so it cannot pass muster under the court's previous standing precedents. And the third challenge, which was rejected, is maybe the most vulnerable. I think Kate will touch on this more later, but that the equal protection challenges were not properly before the court due to lack of standing. So the court was not able to reach a decision on these issues, that it discriminates on the basis of race and the non-delegation argument. They weren't able to reach the merits on this issue. And before I hand it off to Greg and Kate, I just want to say that a takeaway that I had from the first issue was that while the Supreme Court the majority is continuing on its path of like, okay, commerce isn't just in this little sphere of trade, and economic activity. It's greater than that. They did mention that it's not that it's, no, there is limitations to it. And they didn't describe though, or they didn't tell us what those limits are. So I mean, it could be good, bad, you know, so more flexibility for arguments in the future, maybe, but maybe silver lining there. So that was my take here on the first issue. On the second issue, it's nice that they echoed what I felt like was already existing precedent, that distinction for purposes of anti-commandeering, the distinction between state courts and state agencies. So it's nice that we have the solid new precedent to touch on in the future if there were any future attacks on ICWA. Anyway, I'll hand it off to Greg. Thanks, everyone.
Great. Well, I'll take up the baton. Thanks for the invitation to be here. I am not a practitioner. I am a legal historian, so it's a little funny that I'm here. Although I will say this last year, sometimes I felt a little like a practitioner because I ended up writing all these amicus briefs. And one of the challenges of being a legal historian at this moment is that my work is dangerously relevant. I wish it were not, but this is the world that we find ourselves in. And so my role in this litigation was particularly involving the constitutional challenge that Alyssa talked about, particularly the question of, or I should say, the question of Article 1 authority. And let me give a little bit of background and context here, because I think it requires understanding the case in a little bit of a longer perspective, which is, you know, if you look back at the precedent, there's always been this sort of swirling question where the federal government asserts broad authority over Indian affairs, both as against states and as against tribes. And this will become important in a moment. But it's always been a little ambiguous about what the source of this authority actually was. And the key precedent, Kagama, from the late 19th century, at least vis-a-vis plenary power, actually as against plenary power, both against tribes and against states, says, you know, look, we look to it's not rooted directly in the Indian Commerce Clause, but in sort of the broader territorial sovereignty of the United States. And federal Indian law scholars have long challenged and questioned this view. There's a whole bunch of articles, you know, from the 70s and 80s challenging the idea that the federal government has this broad, untrammeled authority to regulate tribes. And what's interesting is in the Lara case in 2004, Justice Thomas writes this concurrence where he says, yes, actually, maybe it's time we also reevaluate plenary power. What's interesting is whenever I teach this case to my students, some of them are like, yeah, this needs to be investigated. But some of them are like, this is a trap. And I think what becomes increasingly apparent in Justice Thomas's later views is that this is, in fact, a trap. And why is this a trap? Well, for tribes, the problem is that Thomas's vision is not sort of a defense of tribal sovereignty as against federal authority. Thomas's vision is firmly rooted in a sort of federalist vision in which, in the absence of federal authority, power ends up in the hands of the states. And he reiterates that view in repeated concurrences, including in adoptive couple. So this case that we already heard a little bit about back from 2013, Thomas writes this extensive concurrence, ostensible concurrence, in which he sort of says, and by the way, I actually don't think Congress had the power to enact ICWA in the first place under the Indian Commerce Clause. And that was basically an invitation to a bunch of conservative litigators and activists to bring precisely the argument that we see in this case, that ICWA exceeded Congress's enumerated powers. They also add on the anti-commandeering challenge later on in sort of a kitchen sink approach. I won't spend too much time on the anti-commandeering challenge. I think it's a little more distinctive to ICWA and pose less of a challenge to Indian law more generally, whereas the Article 1 challenge was really a broad challenge to congressional authority in this area more generally. So in Brackeen itself, you get Thomas effectively reiterating his view from adoptive couple. Despite a bunch of work, including mine, but a bunch of other people on this question, challenging his views, he doesn't budge and basically says, look, what I meant, what I said, Congress doesn't actually have the authority to enact this. It's not particularly interesting in my view, except to show that Justice Thomas's views seem to be largely impervious to evidence. The majority has to grapple with this question of, it grapples with the question more squarely than it has in a long time, certainly since the Lara case. What it does is more or less what it did in Lara, which is that it repeats the precedent saying that this power exists and that there's a lot of precedent addressing exactly what Alyssa alluded to, which is that commerce does not necessarily mean trade. The Congress is and exercises authority over Indian affairs in very broad ways. The majority does sort of throw the challengers some concessions, as Alyssa noted. It says that the power is not unlimited. It says that the precedent has been a bit unclear. Sure, how much to read into that, and we'll talk a little more about that later. I actually think this is mostly throwing some concessions to the challengers. I don't think that this is a major re-envisioning of the precedent going forward, because I think it's unlikely, I think this is sort of what, if you are a conservative justice, you are obligated to say that Congress's power is not unlimited. It is the sort of thing that you always have to talk about the fact that this is a Congress of limited and enumerated powers. And I think that's effectively what they're doing. They do sort of hint at the fact that maybe they're looking for a new theory that could impose some additional limitations. Again, that's something we could talk about a little more in more detail later. By contrast, I think Gorsuch's concurrence presents sort of an interesting theory of federal power in this area. And I will say this, Gorsuch's concurrence grows out of one of my own frustrations, which was working on this case, where whenever I talked about my argument, saying, look, Congress, actually, if you look at the historical evidence, it suggests broad congressional authority, at least vis-a-vis states, in Indian affairs at the founding era. People would say, oh, you're defending federal plenary power, as if that was sort of a simple, unified thing. But as I noted earlier, there's really two separate questions that I think have to be disaggregated. There's the question of federal power as against the states, and then there's federal power as against the tribes. And the case based on the historical evidence for broad federal power as against the states in Indian affairs, I think, is very strong. I actually think it's almost overwhelming. By contrast, the case for federal power as against the tribes is much thinner. Of course, it's complicated. It's not that there's no evidence, but it was not grounded in sort of specific constitutional provisions. And there's no question that it looks very different when you look at it from the late 19th century as opposed to the founding era. And so if you view carefully to an originalist perspective, actually broad federal plenary power as against tribes is not particularly tenable. And that's basically what Justice Gorsuch's concurrence argues, right? Justice Gorsuch distinguishes these two sorts of federal authority. And he says, look, there's lots of founding era evidence to support federal power to enact the Indian Child Welfare Act, including the Indian Commerce Clause. But he goes on to say, look, the idea of federal plenary power as against the tribe, this idea that grows out of Kagama, that is not clearly rooted in the historical evidence. So this is something I think a lot of Indian law scholars have been arguing for a long time. It's something that the field has been pressing hard on. And it's striking to see Justice Gorsuch take this up. He says a lot of other things in the concurrence, which is, remarkably grounded in the history, not only the sort of historical evidence of congressional authority, but also the historical trauma that was inflicted on Native peoples that he really foregrounds in a way that none of the other opinions do, which I think is noteworthy and significant. Where it goes from here, well, that's something we'll talk about in a moment. I think it is striking that at least that part of the opinion, Gorsuch only has himself. He's speaking, the other justices do not sign on to his theory, novel theory about congressional power in this area. So it'll be interesting to see how that unfolds. But I think it is noteworthy that this vision of federal authority is now, there's sort of a full-throated defense of it in the US reports.
And I thank you, Greg, and just to shout out to both Greg and Kate. So what Kate is writing a footnote for is the next edition of the Cohen's Handbook of Federal Indian Law. So everybody really will have it. And Greg, as a young PhD student, was looking at that Thomas concurrence and saying, we need to push back on that, and wrote this fabulous article. And I was like, okay, I guess you could. So great for both of them. I just wanted to talk a little bit about the equal protection side. So as has been mentioned, a lot of this got going with adoptive couple versus baby girl in 2013. And as opposed to Thomas's idiosyncratic concurrence, the majority in that case was just, even though it didn't decide any issues about equal protection, put race front and center, said, this is about a little girl that is Indian because she is 1/232nd Cherokee. That's completely inaccurate. If you look at who is an Indian child, it was because her dad was enrolled in the tribe, she was eligible for enrollment in the tribe, and so on. But that was the theme. And they said that if we ruled a different way, it would raise serious equal protection concerns. And that just set loose a group of lawsuits that Kate with the clinic and others on this call have been pushing back at. And Brackeen was the one that survived to the Supreme Court. And the argument was that the placement preferences of the Indian Child Welfare Act violate equal protection because it says absent good cause to the contrary, a child should be placed either with their immediate family, with a family that is from their tribe, or if that's not available, with another Indian family. And so the argument that the state and the individuals were making was that this discriminates against non-Indian parents. And the Supreme Court, although this got a lot of traction in the federal district court and kind of confusing traction in the Fifth Circuit, the Supreme Court said, you don't have standing to make this argument. And there were lots of arguments against standing on the equal protection claim, but the one that they addressed with the individual parties was, you're asking for the federal government to stop enforcing these placement preferences. As Kate said, ICWA isn't enforced by federal courts. It happens in state courts. So this is not going to have anything to do with enforcement of these placement preferences against you. So you don't have standing to make that. Another day. Same thing with respect to Texas. Texas was saying, oh, it offends us so much to enforce this, and because it offends us, we have standing to raise this equal protection thing. Or maybe we've pledged to our citizens not to violate their rights on the basis of race. And the Supreme Court said, that's not standing. That would allow states to complain about any federal law they don't like. And so it just didn't decide those questions. And the only opinion that addressed these really head on was Justice Kavanaugh's, as not moving opinion, two paragraph. I think this is a real problem. I think it discriminates against people because of race. Justice Kavanaugh, by the way, in Rice v. Cayetano, which was a 2000 case about the 15th Amendment and Native Hawaiians, wrote a brief kind of making the arguments that were recycled in the Brackeen case. So we know where he would go on that. But the tone, at least in the majority opinion, and actually none of the opinions took that blood quantum is deciding this. Justice Gorsuch's concurrence really emphasizes the political status of tribal governments. I think Justice Barrett's opinion doesn't point one way or the other on this. I really saw her as a big swing vote on that issue. But so equal protection questions not decided, not touched by this case. Maybe turn over for Kate, who really was involved in this case from the very beginning.
Yeah, so I recognize a lot of names on the attendee, but just for those who don't, the clinic back when this was filed in October, originally in the Northern District of Texas in October of 2017, worked with the law firm Kilpatrick Townsend, specifically Larry Roberts worked with us, and we recruited some tribes to intervene as parties, because as we talked about, and it's really important from that standing perspective, this is a case, Brackeen's a case, right, where you have 3 foster families and 3 states suing the federal government over the constitutionality of ICWA, which means you have no tribal participation at all in that setup, other than as an amicus brief, which means when you're amicus, you can't file motions, right? You can't appeal, you can't file for stays, you can't participate in discovery. Not that we got to do that, but that is the kind of a thing that only parties can do. So 4 tribes intervened quite early. They were my clients through the entire case, so 6 years of that. Navajo Nation intervened for the purposes of a Rule 19 at the trial level, and then intervened for the purposes of appeal. The tribes that I worked for was the Cherokee Nation, the Oneida Indian Nation, the Morongo Band of Mission Indians, and the Quinault Indian Nation. I just would say, and so I actually was teaching my class this morning, and they were asking me about the equal protection question, and they were asking me about SFFA, the other case that the court decided on affirmative action, and how do these interact, and what does that look like? And I was just having a little I just spent 6 years thinking about this, and I'm so happy I haven't had to think about it recently. The standing issue is a really fascinating one to me because of the way she reached it by saying it was the feds and well, we can't possibly talk about this. Nothing we say will change how states practice. And I'm like, well, you're the Supreme Court. As we know from this last term, if you wanted to reach a decision, you will find a way to get there. I think the court's standing doctrines are extraordinarily, weak, difficult to parse at this moment. And so I take some comfort from the fact that they didn't reach the question, and that no one minds Kavanaugh's sort of foot stomping concurrence, right? Roberts could have joined that. It's a concurrence. He was in the majority. He could have said, yeah, actually, I'm concerned about this as well, and here's how you should bring this. I don't think, the students today, and I said I had to talk about standing. I don't see a way to get there through a federal court. And I think the strategy of going to federal court was that these are judges that aren't familiar with child protection, right? Alyssa, they're not practitioners. They're not familiar with child welfare, or child protection, or ICWA, or sort of what tribes and practitioners do on a daily basis. But I think that ended up being, obviously, that was what undercut their claim, was that they had brought this in federal court against the feds and not in state court against the state. So the question of, would you get a case that is structured essentially with a non-native family fighting against an attempt to place a child with a tribal family, a native family that is not that child's tribe? That's the structure you'd have to have. You'd have to have the third, right? And Alyssa's when do we almost never, we use the third placement preference, but we very rarely fight about the third placement preference. The fight is always non-native family and 90% relative, 10% member of the Indian child's tribe. And very rarely, I've never done an appeal or a full fight where it's against this third party, different tribe parent. And I think part of that is you have to start asking the logistical questions, which made my co-counsels bonkers, because I'd be that never happens. And well, pretend it happens. I'm how would it even happen? Who goes and finds a family from a different tribe to come in and then get into a fight in state court in a foster care place? It's just, so it can happen. We could get standing that could bring it, but it's just one of those very unusual scenarios. And I think one reason why they weren't able to bring that case, and I think my co-counsel, Ian Gershengorn, who argued that at the Supreme Court, was the one who was really revived the standing conversation in that oral argument, I think, by pointing out what he started calling the Maine to Arizona problem. We're not talking, that's just not what we're talking about here. So, and I'll stop now. I can talk about it a long time.
Thank you. So we want to, one of the challenges, I think, in talking about challenges to the Indian Child Welfare Act and the Brackeen decision specifically is that it is both like, it's tempting to sort of think really big. So is all of the future of Indian law and all of the questions about affirmative action and race all tied up in this one case? And what does it mean for everything? But also it is a law about Native children, and fundamentally the people who would be the most affected by it, even though the decision could have affected all of Indian law, really would be immediately the children and the families who are connected to those children and the attorneys who are litigating that. So we want to pivot a little bit and go back to that discussion. So how, if at all, has the decision changed the world for practicing in this area? So when we thought about, when we planned this webinar initially, we didn't know how the court would come out. So that question might have been, the court struck down ICWA or some parts of ICWA, and what does it mean for you? So everything is upheld. Has nothing changed? Has it strengthened or weakened the protections? Are any of the questions a little bit different in court now? And then in particular, I'm curious about whether it had an effect, or whether any other recent cases have had an effect on navigating the tribal state relationship in these cases.
I think that's me next. Is that right? Good morning, everyone, or I guess good afternoon, depending on where you're at. So I just want to, first of all, thank Professor Rolnick for the invitation, and then to the rest of the panelists for their incredible contributions to this work. As mentioned before, I'm Brooke Pinkham. I direct the Center for Indian Law and Policy at Seattle University School of Law. And I feel pretty privileged to be working within an educational institution to pass down my knowledge to future lawyers and judges, so they get it right. So that said, I'm mostly just going to be talking about the work that's been happening in Washington. Of course, Alyssa probably has a lot of great things to say, but the work that I've been doing personally at the Center for, and through the Center for Indian Law and Policy around ICWA probably has not been as ingrained in the community as I would like it to be, but the center continues to strive to fill in any gaps, and there are many gaps. So like I said, I'm just gonna kind of talk about what I've been seeing in Washington over the years, and I just want to say quickly that I've not yet heard of any specific changes in the landscape here in Washington, but I've been in conversation with a lot of key folks and continue to keep my eyes and ears open on how this Supreme Court decision might change the work being currently done. And again, I'm sure Alyssa has a lot to say, has already kind of said some things around that. And I want to also just give a shout out to Andrea Smith, who has, despite moving out of the state to work for Tlingit and Haida, has been providing me some valuable feedback, boots on the ground work. So I don't know if she's on, but wanted to share that. And so, like a few folks have mentioned, Washington state does have its own state ICWA statute. It's been around for about 12 years. And with the intended goal to protect tribal state relations and best interests of Indian children. So those were the set goals. And then in addition, like most other states who have their own statute or ICWA-like statutes, WICWA has worked to strengthen or clarify provisions that go beyond the federal statute. And I just want to say that I think I feel pretty lucky in Washington to have a forward-thinking and educated Supreme Court. One of our justices is not only a tribal member and a former tribal court judge, but has extensive knowledge around the history and importance of ICWA. A few important decisions have come out of our state Supreme Court in the past few years that have dramatically changed the attention paid to active efforts and reason to know. And then I want to also just give a shout out to Ralph Jefferson at Lummi Nation, also my former law school classmate, who has been steadfast at getting the state to adopt the work that Lummi has done, that Robert Ludgate has done in creating a highly comprehensive guide on active efforts. Ralph tells me that Lummi's been pretty involved in working with the state to revise policies and train state workers, and partnering with a lot of Native nations in doing that work. So in that said, I think we're also fortunate that in the state we have a pretty well-staffed Department of Child, Youth, and Family Services. We have a tribal relations department staffed by a lot of Native folks that work for tribal communities. And I do see that work is being done with tribes and trainings, ensuring proper government-to-government relations and consultation. Again, working on reason to know, sort of revamping that and active efforts. And then just work being done to strengthen MOUs and work on qualified expert witness. And also we have a local Indian Child Welfare Advisory Committee. So one thing that the center, Washington State, we're not the highest, but we continue to see a high number of Native children in the foster care system. And so Washington is also home to a high number of Alaska Native families. And while the center has of recent been focusing our work serving mostly Washington tribes, we are working to expand that in serving, finding ways to serve Alaska Native nations and their families. So other work that's been happening in Washington and through our Supreme Court is with the Administrative Office of the Court, who set out a few years ago to make improvements in Washington courts. And again, I think Alyssa's been involved in this and maybe can say more about it. But one of those things I think they've been working on and I think was mentioned earlier was increasing the amount of ICWA courts in the state. I know that many folks are seeing favorable outcomes in those specialized courts, and that work that's, in addition to being led by the office, the Administrative Office of Courts, we have a tribal state court consortium, which is a joint effort between state and tribal court judicial officers and other judicial branch members that expands communication and collaboration between state and tribal courts. So that's some of what's happening in Washington. Of course, there's a lot more, and I think Alyssa can really speak to in more detail. But of course, there's still work to be done despite the outcome of the decision, the Supreme Court decision. Funding is greatly needed in various programs, and I would like to see a lot of that funding going directly to tribes. And so that's all I have. Thank you.
Thank you, Brooke. So I'm going to try not to word vomit right now because I have a lot to say. I won't touch too much about Washington State because I think Brooke did a great job on explaining all of that. I do want to echo what Brooke did say about Washington State and how it is. We're pretty lucky to practice here as practitioners in federal Indian law. Indian law in general, because the state is forward thinking. In fact, just recently, the state enacted the Keeping Families Together Act, and there are a lot of key provisions in ICWA that are there, and maybe even a higher standard. For example, it's really family centered, and because the state of Washington has just decided that research has shown that the children in foster care do so much better when they are with families. And so we need to keep them with their family. If a family member, if there's an issue with a family member placement, we better be trying to safety plan around it to keep that with that family. And so in particular, the legal standard for removal now under the Keeping Families Together Act is, it's quite similar to ICWA's and WICWA's in that you have to articulate that removal is necessary to prevent imminent physical harm. And that's huge. That is a much higher standard, and you have to really point to causation, just like under WICWA. Like this thing in this condition, let's say a home, makes it unsafe for this particular child, and it's not unsafe, it's imminent. physical harm. And so I definitely agree with Brooke, and their ICWA, it's the gold standard, and it's nice that what we are in a state that recognizes that and is starting to actually implement its gold standard in all cases. So I already touched a little bit about what it's like working with Washington State Court. You know, our as Brooke already said, you know, pre-Brackeen, our practitioners are very aware of ICWA and ready to use its protections, its provisions in courts for its clients already. Out of state has been interesting, and I alluded to, like, you know, it's theoretically like we have to try to make things a little more consistent when there is a removal of a tribal child out of state from the tribe. Hasn't always been that way. Pre-Brackeen, it was not uncommon for us to intervene in a state court matter where the practitioners have never heard of ICWA before. And so, and it was an interesting atmosphere because it was almost like the practitioners and the court was more defensive, you know, about like defending their authority over this case and the tribe's ability to intervene. They didn't, we heard preemption arguments made by opposing counsel in those cases. And I guess that alludes to now what it's like post-Brackeen. I feel like it definitely has strengthened our ability to go, and also for other reasons too, as Kate's mentioned, she's making that handy chart or that list of all the other states that have enacted their own ICWAs now. So that'll definitely helpful for practitioners. But it definitely has strengthened because Brackeen went all the way to the Supreme Court. I'm not having to educate as much what ICWA is. We are always going to be educators, always, you know, but it hasn't been as much like, oh, there's this thing called Indian Child Welfare Act and it exists because of this. So yeah, that's not so much. Now it's just more like, oh no, we have a right to intervene. And honestly, the biggest problem that I still face is the ProHack BJ. Like that just happened to me a couple months ago. Still.
It's brutal and it's so expensive, and people do not understand like how rough the ProHack piece is. I've got to do one in Tennessee like when I'm done here, and it's a mess. It's miserable. Yeah. And there are some states, luckily Washington, right, where I don't have to do anything. I just say I'm an attorney in good standing representing Clinket and Haida, and I'm in. But
and you're good in Wyoming now, because I just went. Yep. That was just where I just had that issue 2 months ago. And so then I had to argue with the prosecutor and I had to go through their research, their own bar rules for him and show him where it says I'm allowed. But anyway, and what was interesting is, and then I don't know, it just depends on I still get pushback from practitioners. Like I just had a parent advocate who for some reason, as soon as the tribe was filed its notice of intervention, he submitted this preemptive a request for the Wyoming State Court not to transfer jurisdiction to the tribal court. I'm like, we haven't even asked for that yet. Like, why? Like, we normally don't even do that under the tribe zone policy until if and when this child is indeed adjudicated as a dependent. So that's kind of, we aren't seeing as much of that anymore. But overall, I feel like it's strengthened because there's more awareness because of the profile of the case going all the way up to the Supreme Court. So there's that. I think those are my big things. I know, Addie, you had a particular question about how this between the tribes and the states. I just can't recall it though.
Yeah, and I think it's okay. So it's okay for you to come back in if you have thoughts. What I thought we might do is go to Deborah. She's in a different state, and let's kind of hear about that landscape there, and then you all can pop back in as you think.
Sure. Well, the landscape in Oklahoma has been very interesting, to say the least, within the last 3 years. While we were anxiously awaiting for Brackeen, we were also anxiously awaiting for the Oklahoma McGirt v. Oklahoma case. That was a case that had definite implications as we were trying to navigate the landscape for criminal justice implementation within the Chickasaw Nation. We were kind of keenly aware of, how this may affect other aspects of law, including Indian child welfare cases across the state. So around the same time, we were just working with other tribes to discuss our own respective implementation. We were also thinking about how we would, try to approach the state when it comes to provisions for jurisdiction, possibly concurrent jurisdiction that could be exercised within the reservations, which is allowed under the Indian Child Welfare Act. So in August of 2020, an agreement was developed, and it's called the Intergovernmental Agreement between the state of Oklahoma and each of the 5 tribes regarding jurisdiction over Indian children within each tribe's reservation. That's a mouthful, but basically it's an agreement that provides for a way to streamline the jurisdictional provisions set forth in ICWA. It created concurrent jurisdiction in certain aspects, and then also maintained exclusive jurisdiction when it comes to certain land status within the reservations. It is, I think, still kind of a work in progress. We're continuing. I know Alyssa mentioned education. I think that's one big piece of this agreement, is that even though it was approved in 2020 by each of the tribes in the state of Oklahoma, it is still an education, especially when it comes time to, handling each case. And there are certain provisions for notification. If DHS is, our Oklahoma Department of Human Services is notified, what steps that they will take to notify the tribe, in our case, Chickasaw Nation. But I would say that as far as kind of the relationships between the state of Oklahoma and tribes, that still are issues to be resolved. But I would say that on the local level, on the county level, those relationships continue, possibly in spite of, the larger state tribal relationships, because they have to, we have to provide for those protections for Indian children, especially those within our tribe's reservation. So that's been like I said, a work in progress. We continue to kind of battle with those out-of-state restrictions as well for Hakvichi. I think that probably accounts for the somewhat limited numbers of cases that we can be involved with on the out-of-state level. One of those cases Kate mentioned was a case in Colorado. So, those are things that we continue to handle, kind of work through, and just continue to build those relationships, and also just the education level for not only our staff, but for the agencies and departments that we work with across the state of Oklahoma and outside of the state.
Yeah. Colorado is a hot mess. And there's a case I haven't posted to Turtle Talk yet because it's just got me angry right now, but they have dismantled their reason to know standard. They used to have one of the best in the country. They now have the worst. This is the second time they've done it. I don't know what's going on at that Supreme Court or what they're up to, but it's been making me crazy. I would say what I'm finding, which is really weird to me, and there's some questions I know we're going to answer at the end, but I'm getting a ton of existing Indian family cases again. I'm on my third. I've had one in Ohio, one in Illinois, and now we're in Tennessee. And it's like, and it's foster parents. That's the part that I don't know how to, right? We've done so much work on educating state judges and educating agencies. And like Washington has spent years since the ZJG case, right? Doing education for and work on their agency. And now what I have is people coming in, foster parents coming in and attempting to intervene and then objecting to either transfer or the placement preferences, and they've been using EIF again. I was like, it's giving 1990s out here. Someone asked Deborah if you were going to talk about SJW. I was going to ask if you were going to talk about SJW.
Well, that's a more recent case. In fact, I think we received word that the Oklahoma State Supreme Court had denied the rehearing on that. That has some implications to this particular agreement that I was just speaking about. But yeah, there's just litigation all across the board, especially, I mean, this was a more recent case involving a child who was not a member of the Chickasaw Nation, but was a Muskogee Creek child. But it was a case arising under ICWA in one of our counties within our reservation.
Thank you. So here's, so I wanted to add, I think that she may be here as a participant, but Assemblywoman Shea Baucus couldn't join us as a panelist today, but we're talking about the states that have passed state child welfare legislation, and Nevada sort of just joined the ranks thanks to Assemblywoman Baucus's bill right before the decision. So for those who are here getting Nevada CLEs, we may be able to do future programs on that law, but we're happy to be on the good side now here in Nevada. So we're going to pivot again. We have a lot of questions in the Q&A that are very specific, kind of about how what's going on in the cases as they're being litigated. So I want to sort of pivot back one more time to the big questions, and that's our last formal question for the panelists, and then we can move on to Q&A.
Sure. Interesting outcome in the case, and a lot of people had made plans, as Addie mentioned, depending on which way the case is going to come out. So we know how it's come out. What do you see now in the future? What does the future hold for tribes under ICWA?
So from my perspective, it's like twofold of an issue. And one is there was a lot, I think the sigh of relief that happened once the case came down and it maintains a status quo sort of means it's hard to get motivation to do the work that we still know we needed to do before we spent all of our time on this case. And so trying to get back that energy to be like, no, ICWA is a Band-Aid on a much larger broken system, not like a small one, but we have a broken system as it serves parents and children. And ICWA, we're very lucky to have it for Native families, but the goal, I think, is to not have Native families in the system in the first place, right? Like that's where you would prefer to be. And so there's still movement on other state ICWA laws. We're working, the Uniform Law Commission is still in a study committee to determine whether there should be a uniform state ICWA law for states, for example, that don't have their own ICWA laws, or states where there aren't tribes. Like I said, the states like Tennessee or Ohio or Illinois, it would be fantastic if we could get that. I think issues involving, one of my big areas has been funding for tribal justice systems and tribal agencies, like figuring out ways to get pry some of the money out of the federal government without requiring the level of bureaucracy currently required for all tribes to access that funding is massive. The question of, I always want to know, are there more lawsuits brewing? And like I just mentioned, I haven't seen sort of the coordinated federal attack that we saw coming out of 2013. I think part of the issue is you had two very different groups that came together to bring these, right? So you had your sort of general conservative legal movement, Gibson, Dunn, sort of people who are concerned and would like to sort of undermine all of tribal sovereignty for all sorts of reasons. And then you have the more sort of true believer adoption attorneys that are still out there like causing problems, or the groups that involve in that. And for Brackeen, they came together. I'm not sure I see Gibson, I think in losing at the Supreme Court, that they're going to find another way they want to go. I'm not sure that they're going to use ICWA to get there the next time, right? I think that's part of it. And it's hard to coordinate across state challenges. It's much easier to coordinate a federal challenge trying to get into different circuits. And so what I am seeing, like I said, is mostly foster parent challenges to the law. And there is, I believe, a reporter working on a fairly large national publication discussing the increase of foster parent intervention and how big of an issue that is. And the Colorado Office of Parents Council, which is the one good thing, well, we won part of that case, Deborah, but the other part we didn't. But one good thing was contacts with that office, and they are actually collecting data and have provided data on how reunification plummets when foster parents are allowed to legally intervene, and how much a case increases in cost when foster parents are allowed to legally intervene. It's the first time we have data on something that I think people who do this work recognize happens, and is a real issue. So my future is very the same as it ever is. It's funding, reform, education.
So I'll jump in. So I should say I came into this case not as someone who is an expert on ICWA, and most of what I learned about ICWA I learned from the people on this panel. I came into this case as someone interested in sort of questions of federalism in Indian law and Indian affairs more generally. And, you know, I think I'm not super optimistic about the future in that area. You know, I don't have a crystal ball, can't say for sure what the court is going to do. I will say, I think this case is the end of the road for this particular constitutional argument about the Article 1 powers. You know, I think Justice Thomas floated it, and there was a lot of effort to try to gain some traction. And at the end of the day, it's clear that Justice Thomas is sort of out there by himself. Even Justice Alito didn't really, he offered his own rationale, but didn't really subscribe to Justice Thomas's views. So I think that this particular line of argument is probably not going to go forward. The invitation from the court to sort of float a new constitutional theory, I think we might run into some of the same challenges that this argument did, which is it's very hard to make sense of the court's precedents without acknowledging sort of broad federal authority over Indian affairs more generally, right? Like, if you are an originalist, the fact that the United States has been doing this since the 1790s makes it very hard to persuade judges. Not impossible, because again, it's always an open question of how much evidence actually matters. But it is evidence is at least a hurdle here, and I think that's going to be a challenge. Instead, you know, I think I don't want to rest too much on Brackeen, because I think it's also important to remember Brackeen was this important victory, but there are a lot of other cases that the court has been hearing, and they've been going poorly, right? I mean, in some ways, I think we should remember Casper Huerta, which is not only, you know, was I think a really important loss in terms of the effect that it will have for tribes more generally, but also the reasoning of Casper Huerta, I think, is incredibly dangerous. You know, the dicta that Justice Kavanaugh wrote into that opinion about how tribes are ordinarily just part of states, and sort of gratuitously citing the 10th Amendment, I think that language is dangerous. And I think one of the things that's clear from the last couple of terms is that Justice Barrett is very clearly the swing vote. And so the fact that she signed on to Casper Huerta, that she was in the majority in the Navajo Nation trust case, both of those I think are worrying. And I think what they signify is not necessarily that we're going to see a revival of these sort of broad constitutional attacks, because I always think that was a little bit of it was a very risky move for them. Instead, I think what we will see is something more like Casper Huerta, where they will say that the federal government, theoretically, it has this authority, but it hasn't exercised it. And even if there's, you know, 2 centuries of precedent on the other side, there's always the danger that, especially if you're a strict textualist, you can say, well, it doesn't say that in the statute, which is effectively what the argument was in Casper Huerta. And if you put the thumb on the scale on sort of broad structural principles in favor of states, which I think is what Casper Huerta does, I think that's a very dangerous combination. And so I'm worried about the state tribal fights in the wake of McGirt, you know, concentrated, as Deborah pointed us to, in Oklahoma, but with much wider ranging consequences. I worry that those are going to escalate, and I think they're going to go back to the court, and I worry what this court will do with them. Because we're already seeing efforts to try to use Castro Huerta and expand its holding to new areas and limit the scope, expand the scope of state jurisdiction and potentially limit the scope of tribal jurisdiction. So that's honestly my concern. I will say one other brief concern is, the court also kicked out the non-delegation challenge on standing grounds. It didn't give it much attention, but I do think the non-delegation challenge fits very nicely with conservative legal movement lawyering right now and their views on the administrative state. It is, of course, also a wholesale attack on tribal sovereignty, but I think I would be worried about how the court might address a future challenge. Let's say, I don't know, in the context of, let's say, a challenge to the VAWA jurisdictional provisions or things like that. That argument, I worry, could come back in future cases. I don't think it's settled by any stretch of the imagination.
Yeah, and just following up on that, the equal protection challenge could definitely come back. There are lots of good arguments about that make it hard for individual foster parents to get standing in these kinds of things. And that's part of the reason that the Brackeen challenge got so far, is because Texas was a plaintiff, but they don't have standing in equal protection. But that is definitely an avenue of challenge that could continue. And as I think I hear slightly different things between Greg and Kate. We don't know how Justice Barrett would go on that. And I'm not even sure how Justice Gorsuch would go on that. He really, it is all his work, all his opinions in Indian law has emphasized the political status of tribal governments, which is very consistent with Morton v. Mancari and the other cases that would place us in different equal protection land. But I think it's a bit uncertain. And those challenges can be raised in other places outside the ICWA context. So the arguments that were made in Adoptive Couple versus Baby Girl by Sam Clement, I always get his first name wrong. Paul. I always confuse him with Samuel Clemens. That's my excuse.
That's awesome.
I'm in the home of Mark Twain, the Hartford home, not the actual home, but the place where he lived. Anyway, Paul Clement made those arguments about equal protection that he made in Adoptive Couple versus Baby Girl a few years before that in KG Urban, this First Circuit case, saying that this state action regarding gaming violated equal protection. Of course, when you attach a case to children and say, oh, it's the children at stake, it gets a lot more traction than it does when you're talking about game, when it's like some non-Indian gamer, it's like, we want a game too, but those could be out there as well.
I just want to say, go ahead.
Oh, I was gonna say, I stopped worrying about Gorsuch when the Coughlin decision came down like 8-1. I'm not worried about him anymore. And I tend to agree. I think I agree with everything Greg said, actually, but I'm in a very narrow world of ICWA, and I'm not as worried as I was, is what I would say.
Yeah, and I will say I actually agree with Kate. So there we are, a radical agreement, which is I'm a little less worried about the equal protection challenge. For some of the reasons that Kate pointed to, the fact that no one else signed on to Kavanaugh's concurrence. I think in Indian law we have a 5-4 or 4-4-1 court, right? Having Gorsuch with the liberals, I like Kate. I think Gorsuch is relatively predictable, solid vote at this point, and so I think that changes the dynamic considerably. So I'm much less worried about the equal protection challenge and much more concerned about sort of the structural federalism, statutory concerns that I alluded to earlier. I think the post-McGirt challenges are going to continue to play havoc with some of the foundational principles in the field. I think Castro Huerta is a terrible decision for a lot of reasons, but I also think one of the reasons it's a terrible decision is, it's a little like, it reminds me a little bit of City versus the City of Sherrill, in the sense that it's one of these decisions that's sort of broad and vague and can be cited in lots of different contexts, and has some very unhelpful dicta, and can sort of will run amok and cause a lot of damage. Now, hopefully people will not do that and will construe it more narrowly. But that's my
So
feel.
so far Oklahoma hasn't. So
Right. Yeah. Didn't SJW rely on Castro Huerta? Yeah.
Oh yeah.
I just wanted to ask one follow-up before we go to the Q&A on the equal protection question. So Bethany, you talked about how that argument kind of travels in different places. So we saw it in KG Urban in the context of gaming. So in the Maverick gaming case out of Washington, it also resurfaced again, I would say in a much sloppier way that didn't seem quite as dangerous. So I think there's sort of two versions of it. And one version is sort of attacking Indian classifications all across the board, most of which can sort of easily, or I think we all think easily, be defended as political classifications. So that was the case, I think, in KG Urban. And in the early iterations of Brackeen, when there was an attack on the Indian child classification, that's sort of that version of it. So you can defend that sort of classification. Where it ends up in Brackeen is a challenge to the other Indian family, the non-citizen type classification. So citizens of other tribes, but not citizens of that tribe. And there's a couple of other areas in law, most notably, I think, in the context of criminal jurisdiction, that I think is getting some traction in Oklahoma, where the definition is not based specifically on membership in that specific tribe. So Kate, it was helpful to hear you talk about how you don't really see, in a practical sense, a good challenge coming forward by the third placement preference people in that context. But what are there other contexts in which equal protection challenges might, at least limited contexts, where in Indian law they might be vulnerable?
I mean, in ICWA, and to be clear, I thought we were going to lose Brackeen, so I'm not your predict the future person. I'm very, very bad at it. So it's possible tomorrow there's a challenge that they find that works. I would say, right, the existing Indian family exception in California was essentially used to create a constitutional challenge. Like, if we apply the placement preferences to this child, we'll be violating certain provisions, and some of them go sort of equal protection-y. The other place that I know there's some worry about it happening in the context of state ICWA laws. So the KG Urban case came up again, right? So what is the authority of states to act on behalf of Native children? Does that end up with a challenge? Certainly the Iowa ICWA was challenged in that way when they defined Indian child in a very broad context, sort of any child recognized by the Indian community, right? They didn't tie it to tribal citizenship. And that was struck down by the Iowa Supreme Court. So I think, and Bethany alluded to this, like, anytime you're talking about cases that involve kids, you will get every single argument under the sun if people are willing to make them. And so I think it's incredibly, and Alyssa might want to talk to this, I think it's very unpredictable. Like, you can end up, I have an order that just came in the door from Alaska denying a tribe intervention in an ICWA case. It's intervention, it's 1911, I know, it's 1911, it's like, it's an automatic thing. And here I am, like, she's like, can you help me with this? I'm like, I don't understand what's happening. So I think, yeah, it could come up through an ICWA case. I hope not. I'm trying to just pretend like it won't and not worry about it.
And tribal attorneys in Connecticut tell me that intervention is really a big, hot question here. This is something that I know. It's like, what?
I don't get it. That's why I always just call it notice of intervention, so that way they think, oh, they don't have a choice.
Yep.
So that's what I always characterize it as that.
That is an excellent practice tip for practitioners. You just file your order, you just file it already ordered. Yep.
Okay, so let's move over to the Q&A and then Panelists, I just want to invite you to answer questions and also make additional comments that you haven't been able to highlight. So I wanted to start with what is a question that has been plaguing me. So the question is, can someone speak on the portion of the majority opinion that says ICWA doesn't require state social workers to do anything? Just a little bit, I'll read the passage that's in there, but in addressing the placement preference section, the majority opinion says this argument fails for another reason. Section 1950 doesn't require anyone, much less the states, to do anything to search for alternative placements. As the United States emphasizes, petitioner's interpretation can't be squared with the court's decision in Adoptive Couple, which held that there is simply no preference that has to be applied at all if no alternative party that is eligible has come forward. The burden is on the tribe or other objecting party to produce a higher rank placement. So the anti-commandeering argument fails. So that worried me when I read it, which is, it seems like there's something in the Supreme Court saying states, you don't actually have to try to find a preferred placement. And I wonder what people have seen.
Yeah, I mean, I think that's right. And if you look at 1915, so I want to be clear. The question was, doesn't require state workers to do anything. And I do want to clarify that the language of that is situated in the 1915 discussion. And so I will make I would argue for a long time that that only has to do with doing essentially the diligent search for placement preferences. Whether you want to point out to your court that the regulations maintain this, even though she didn't mention the regulations, that I don't know that's going to fly, but that the federal regs do require state agencies to still do due diligence. And actually the only language in ICWA that requires agencies to go look for alternative placements is in the regulations. The 1915 describes the placement preferences, but it doesn't say state agencies have to go looking for alternative placements, whether we wish that were the case or not. So on one hand, it made me very anxious when I read that. On the other hand, she is not wrong that that's what the federal law says. There are a couple different things. This also falls under the commandeering section. So for the purposes of state laws, in Michigan, our state agency is required to do due diligence to find alternative placements. That didn't change with this language because it's state law, not federal law. So that doesn't help this poor person who apparently is in the middle of a brutal ICWA case right now. But I just want to be really clear that there are ways to cabin this. And I'd also say that the second part of that is, she says, agencies may not have to find alternative placements, but courts absolutely have to follow the placements when given. And so does this put an unnecessary and probably, does this put a burden on tribes to find alternative placements? I would say probably yes. On the other hand, most tribes I work with also spend a fair amount of time looking for placements because they know their family's best. And so should tribes be reimbursed for that, like the Alaska model, where Alaska pays tribes to do certain things, like hire a worker to do the due diligence search? Yeah, absolutely. If a tribe brings forward an alternative placement, does the court, according to the same decision, have to follow the placement preferences? Yes, she says that explicitly. Now, do I think agencies are going to be dodgy with this? Yeah, they clearly are, right? Like it doesn't, but I think there are arguments to be made countering that is my response.
So another question, the court's opinion references state decisions regarding private actions. Have practitioners been able to use this in states with non-parent custody laws or uniform guardianship acts, which I think Washington has?
So I was writing a long response to this. I'll just say what I would say. You don't have to use Brackeen to get there. This has been the case for a long time. In Michigan, our case on this is In re Empson Laviette. It's In re SS in Arizona. It's In re TAW in Washington. There's another one in Colorado. I don't think it's BH. It's a different one. If you have an Indian child, and if you have a child custody proceeding that meets the definition of the law, which can include guardianship, third-party custody, grandma custody vis-a-vis parents, or any termination of parental rights, whether that be a step-parent adoption or some other private attempt at termination, which I don't I think step parent adoption is going to be your main way to get there. ICWA applies. And so you can use Brackeen now as a separate citation, but our tribes intervene in those cases all the time.
So there's another question in the Q&A that I think we sort of covered already. I'll just ask it in case there's additional comments, but whether thoughts on, where the equal protection argument might go, and in particular, whether it might resurface with the new ICWA regs about sports wagering off reservations.
Just to jump in, I mean, I'm not familiar with the particular regs, but yeah, it could resurface. Folks.
Anything's possible.
Yeah. There's the interest that there's money behind it, and so there's folks that will try to get lawyers to make the arguments. If they follow the existing precedent, those won't be successful arguments, but that's not something we can always rely on.
I will add that I think that in the context of the tribal gaming, it's particularly a challenge because the political rather than racial argument is particularly compelling when you're talking about a sovereign, right? I mean, when you're talking about the government itself engaging in it, it's hard to talk about tribal governments and their practices engaged in gaming without running sort of headlong into that. In other words, I think the child aspect that people were pointing to earlier, where you emphasize, oh, but these are children, made the equal protection argument much more compelling than it did. Not only that they were dealing with economic activity, but a preference for a tribal government. The governments are not, they are artificial people in a sense, right? They are not natural persons. And so I think it just makes it harder. I mean, what does it even mean to talk about the racial classification of a government? Again, I think Bethany is absolutely right. The argument will be made, but I just think there will be, it's not the most obvious channel. I do wonder if we will see some recurrence of the constitutional argument because of the off-reservation aspect of it, right? The one of the things that Texas placed a lot of emphasis on with ICWA was the off-reservation aspect, and so I think that is somewhere where they might continue to expand. On the other hand, the court sort of bat that back by citing the Haaland decision from the mid-19th century. So with some luck, that won't go anywhere, but I do think the off-reservation aspect is another area where we could see continued fighting and litigation over the constitutional questions.
The place where they got some, and I should have been clear, the place where they got some traction in KG Urban was state actions that weren't required by the federal law, but that seemed to support the federal law. And I think the law is kind of mixed on that, and you could use that in a lot of different ways, and including in state ICWA statutes. So the argument could be made. It shouldn't win, but it could be made, and that doesn't mean a judge won't rule in favor of it.
I mean, I think the area where we're most likely to see the equal protection questions emerge, and actually, Addie, I'd be curious, given your own expertise on these questions, your own thoughts on this, but, I think we could see a combo of the, Brackeen and the affirmative action cases where, tuition waivers for Native students like we have in California and other states are going to be subject to challenge. I mean, I think given how on all fours that is with the sort of constitutional colorblindness challenges that we've seen, I think that is the most likely avenue for future litigation on this. I don't know. That's my sense is where I think this is probably most likely to be headed. Because again, it fits so squarely with the litigation. It seems like one of the obvious next steps after the affirmative action decision.
I want to know what Addie thinks too. That's my theory. I've been saying that since the case came down. That's what I think where it's going.
First, I'll just speak on behalf of everyone who works at a school to say I really hope that nothing happens there. And probably everyone's already involved in it, but anyone who's working anywhere at a school it means that it's really important right now to look at how the applications and the tuition waivers and the application questions and the demographic questions, just the wording of those is going to be essential in order to head off and kind of think about how to deal with future challenges. I think they could resurface. Another way one might look at it is to say that one version of, there a lot of the panelists have talked about how many different interests sort of came together for the Brackeen challenge, but part of the story of how much energy went into the equal protection part of the Brackeen challenge might have been that the eventual target was affirmative action and Indian kids were going to be, roadside casualties on the way. So if that route has been taken in the SFFA case, then maybe we get less pressure in those equal protection arguments in Indian law because they've actually been able to get traction in the place where perhaps some of those people were really going. Now, I don't think that everyone involved in challenging Indian classifications is really doing it on the way toward all racial classifications, but it's definitely related. So I guess my hope is that the focus isn't on taking down the Indian classifications in order to take down everything anymore. But I do think there are a lot of unanswered questions. And when the Department of Education issued regulations or guidance about how to implement, they sort of didn't answer a lot of the questions that they might have answered about tribal status and Indian classifications and recruitment efforts and tuition waivers. And so I think that's an area where there's a lot of work to be done.
So it looks like we don't have currently any other questions in the queue, so I will jump in here. And actually, Greg, I want to start out at least interested in everybody's views, but your opinion, because it would seem currently you may be the most highly prized Indian law historian right now, given Justice Gorsuch's multiple references to your work and his opinion. So given that closeness with you, maybe I thought it would be interesting if you have some insights into what I thought was an interesting, and to kind of take a step back, sort of more into the constitutional area of plenary power. I found it interesting, and I appreciate anybody's viewpoints, but yours as well, Greg. The plenary power has been referenced in numerous Supreme Court cases as an almost unlimited power. Obviously, all powers, even plenary, ostensibly have some limits. But I don't think, and you can remind me, I don't think the Supreme Court has ever actually found a limit yet in an actual case, or reached a decision in which they said that the power exercise was not proper because it went beyond the limits. But I found it very interesting that Justice Gorsuch seemed to take pains to differentiate a little bit from the majority opinion, his views on this plenary power, which I believe he really kind of says, I'm not sure it's a plenary power, I just think it's a really broad power. And what's the difference in that? And if there are limits, what would be something else? Because again, to my poor recollection, the only limit that I recall the court ever really saying would be a limit on Congress's plenary power is this thing that they've never done, which is to say a group of people are Indians who aren't actually Indians, so that Congress can't, sort of take an irrational act to declare any group of people Indians. There has to be some, I guess, historic basis for it. That seems to be the only one, right? Seems to be the only one that the court has repeatedly put out when they say it's a plenary power, but there is a limit. Congress can't do this. What other limitations do you think would be there? And why did Justice Gorsuch go to such pains to say that maybe this isn't plenary power, it's just a really broad power?
Well, first of all, thank you for the kind words about the work. Although I should say that, I think Justice Gorsuch relied on a lot of people in there, Matthew Fletcher, Winona Sigel, lots of people got lots of attention. It really was remarkable how much the collective effort of Indian law as a field, I think, was on display in that opinion. It was really, really quite remarkable. This is something that I think about a fair amount. It's clear when you look at the historical examples what kinds of things Gorsuch might be thinking about, right? I mean, we have these broad assertions like in Lone Wolf where there are basically complete disregard of limitations on federal power. And to some extent, I think the provisions of the Bill of Rights, now that they are applied more forcefully in the context of federal Indian law, do some of that work of checking plenary power, right? So you have the decisions involving the Indian Probate Reform Act, which actually Bethany sent me some comments on, where the court invalidates those for violating the Takings Clause. You have Sioux Nation in 1980, which also applies the Takings Clause. So I think one of the things that's remarkable is in the late 19th, early 20th century, the court seems to effectively disregard those rights provisions of the Constitution in the context of application to tribes. So I think to some extent, some of those provisions are doing some work. It would be interesting to see if we will get, maybe a reinvigoration of free exercise principles in federal Indian law. I think one area where there's some possibility for that might be with the newfound interest in religious free exercise with this current court. Maybe there's some possibility for revisiting Ling or something in that vein. That's maybe a little overly optimistic, but that's at least, I think, some sort of interest convergence story that you could tell. I think Gorsuch has a little bit of the academic in him, in the sense that he cares a lot about ideas. And so I think academics are greatly interested in this question of federal plenary power and whether it is rooted in an accurate reading of the Constitution. As a practical matter, I wonder if this is where, as academics, we should be spending our time and energy, at least in the current climate, right? In the sense that in a world where tribes have become much more effective at lobbying Congress, I'm much less concerned about a return to the sort of assimilation era or the unbridled practices of the early 20th century. Maybe that's naive of me, but I'm much more worried about what the court is going to do in this area than I am worried about what Congress and the executive branch are going to do in this particular area. And so, quite frankly, I'm more concerned about the doctrines that aggrandize judicial power, of which there are many floating around right now, than there are about doctrines that aggrandize sort of congressional authority in this area. Now, that's not to say that we should sort of wholeheartedly run to and embrace the idea of federal plenary power. I agree with Gorsuch. I think it is not particularly well grounded in the history, but it's also not, I think, the most pressing of my concerns at the moment when I think about what the future holds for federal Indian law. I'm much more concerned about what the court will do in re-examining these long-standing precedents, as we saw with Castro Huerta, where it sort of took this statute that was very old and disregarded 2 centuries of precedent on how it has been interpreted and applied. So that's sort of my current thinking about what the future holds in this area. But I do think it is, Gorsuch is this person who likes playing with ideas. And I mean, in this sense, he and Thomas are interesting pairs because they both, even though they disagree so sharply in this opinion, both of them are particularly interested in sort of a kind of purity of the doctrine, right? They want to sort of expunge the errors that they see existing within the doctrine. And I think the majority is much less interested in that in this case.
So I had that thought, interesting, the discussion, if you want to call it that, between Gorsuch and Thomas. And do you think that maybe Gorsuch is trying to take a little sting out of, I know Thomas in this case is sort of on his own here, but not always, right? Is he trying to take a little sting out of Thomas's, this whole plenary doctrine thing is made up. It doesn't have any basis in anything. And Gorsuch is kind of saying, well, maybe it's not a plenary power. It's just a really broad power. But it doesn't matter. It's still a power that Congress is legitimately exercising.
Well, and again, I just want to reiterate, I think one of my great frustrations is this failure to distinguish between federal power as against states and federal power as against tribes. And I think that Gorsuch is trying to make that sharp distinction, and Thomas is blurring it a little bit. I mean, one of the interesting questions is, if you don't think there is federal plenary power here, does that mean automatically that there is state power? Which is sort of what Thomas concludes, right? And that is, I think, where Castro Huerta comes down, and that's why I think it's such a dangerous decision. You know, federal power in this area has always played this very complicated, ambiguous role. One of the things I emphasize when I teach to my students is I describe the federal government as the frenemy of tribes, because of course, if you want to look and find examples of the federal government doing terrible things to Native people, there are abundant examples. If you want to find examples of states doing terrible things to tribes and Native people, there are also abundant examples. And unfortunately, one of the only bulwarks that tribes have been able to use against state power to the extent it existed was federal authority. That's sort of the upshot of Worcester, and that is sort of one of the broad structural truths of federal Indian law. And so I do worry a little bit if we start pulling out the Jenga blocks of federal authority, what happens? Does it mean a resurgence of tribal sovereignty, or do you lead into the Thomas decision? And I feel like that's in some ways what Gorsuch and Thomas are arguing about. I think that's the crux of their dispute. Bethany, I think you wanted to get in.
Yeah, I mean, so the other place where they limit it is Seminole Tribe versus Florida with state sovereign immunity. So the flip side, as you were suggesting, is maybe state sovereignty as a limit on plenary power. And I think, so Justice Barrett, in the majority opinion as well, says plenary does not mean without any limits on it. It just means very broad. I don't know the exact language, and that is a definition of plenary. Nell Newton wrote that, and I think it might have been 1980. So this is another place where Justice Barrett is this kind of cipher. Like, is she thinking about state authority? Is she thinking about it in the ways in tribal sovereignty? She doesn't indicate that in the opinion. So it's just unclear.
I think we have time. I wasn't sure how this was going to go in terms of time and questions. So we've got some time left, and I wanted to just invite anyone to make any additional comments on the panel. Deborah, I don't want to pick on you, but I would love to hear from you. I just think you're at ground zero for like almost everything we've been talking about in terms of these fights. And I would love to hear your response to some of what we've been talking about in terms of what you see happening kind of both within ICWA and also just in general in the context of arguments about tribal sovereignty and state resistance to that, but also to just invite each of you to say anything that you'd like to add at the end.
Well, I will say that what Gregory said as far as, Castro Huerta and all these different, cases just kind of converging, and we seem to be kind of at ground level as far as, how all these things are being played out kind of in real time. It almost seems every day something is the new decisions being made. And, I think that, like I said before, there's just some of these things are, Brackeen, even though it's a decision that was fairly, recently decided, I think still things are still kind of shaking out as far as kind of on the ground. McGirt and the court decision that applied to the Chickasaw Nation and Bosse, that's also still kind of shaking out in terms of not only criminal jurisdiction, but as we talked about with under Indian Child Welfare Act, now we're having contending with kind of all the implications, whether it's civil implications or things that our office has to, deal with on a daily basis as far as being the tribal prosecutors. I think it's just still kind of to be determined for us. There's some, I think we're fortunate in that we have had, good relationships, like I said, on the ground with other, the counties, the 13 counties that our reservation comprises of. And then also kind of learning from the other tribes, four tribes, and the other tribes that have now had their reservations recognized. So that kind of, I don't know if it's brain trust or if it's just that kind of experience, that we all have in other areas of the state. That's been incredibly helpful for us to navigate, how do we deal with this, particular, whether it's ICWA issue or another issue, how did you deal with that in your county? And that's been incredibly helpful for us, just kind of on a day-to-day basis. And then, just not only us as the legal practitioners, but our child welfare staff learning from others, and also just, the power of multiple tribes coming together through associations like the Oklahoma Indian Child Welfare Association and other groups that have helped kind of, have that development of ideas and whether it's, working together or coming up with some ways to improve, our advocacy on the state level, and then also, national level. We've just really tried to also collaborate with our tribal attorneys, trying to have more frequent meetings together, just to figure out all of this as it's playing out.
I would just like to add, I found our practitioners in the chat. We've been sending cases. I do maintain an ICWA tribal attorney listserv that's wanted. If you practice, if you work for tribes, you can shoot me an email at fort@msu.edu. It's not super active. You're not signing yourself up for Turtle Talk level subscriptions. This is just rare announcements, and if people are looking for resources or questions that they're having or issues they're having on cases, we maintain it through the kind generosity of April Olson's law firm, Rothstein Donatelli, out in New Mexico and Arizona. And that I would also just add, some people have brought up really complicated cases. I am not a trial attorney, but I will say one of the hardest things is if a tribe decides they want to appeal or something has gone really south, and the time frame, appellate timelines, as many of you know, but some of you might not, are quite tight, especially at the state in that first state court of appeals. And the sooner you let me know, or the sooner you reach out, the more likely we're able to help on a case like that, or at least find an appellate attorney who can. So if you have a case, appeals obviously are not the best way to solve an ICWA problem, because it just drags the case on, but it is, as far as we know right now, our only option when a court doesn't believe what you have to say, is not following the law. Any of the comments that have shown up in the chat today, sometimes it is unfortunately the only way to make that happen. So I just want to put a plug out there for the work, and if anyone needs anything along those lines. I am not doing, someone just brought up Doe versus Mann. I'm not talking about Doe versus Mann. I've stopped teaching Doe versus Mann. I don't like it. It's that California case on Public Law 280.
Closing remarks from any other panelists? Great. Okay. So thank you. I mean, I just want to say again, this is fantastic. It's I always feel lucky when you all say yes, when I ask you to participate in something like this. It's really an amazing group of people to have in this room to talk about. And this is it's a good decision, and everyone was, I think probably all of us were quite nervous and pessimistic about how it might go. And it's kind of amazing to have the law be upheld. And then it was also like what to make of it is confusing. So there's a lot, and you can see this from the chat and some of our discussion, a lot that still is important about kind of the way in which the law is implemented. Kate, I was really glad that you brought up, you didn't say Title IV, but I think you were talking about Title IV funding, but how to, so on the other side of it, we're talking about state court cases, but on the other end of it is, once the children that are transferred to tribal jurisdiction are there, there's a lot still that needs to be done about strengthening the ability of tribes to have completely fully functioning and child welfare systems that implement kind of the vision that they see. So that's part of the way in which tribal jurisdiction helps resist what's happened in state courts. And one of those is access to foster care funding under Title IV, which I will say is right now it's really hard. So we fought for a long time to try to get tribes direct access so they didn't have to go through states to get foster care funding, and tribes can have direct access now, but the hurdles are enormous. It's very hard to do. And there's a lot of tribes, I know especially with smaller tribes, so this is true in Nevada, it's true in Alaska, the kind of data resources that you have to have in place and the staffing that you need in place, it's an insurmountable barrier for kind of smaller courts. So really thinking about ways to make sure that tribal courts have the resources, even though we talk a lot about the fights that get more attention that happen in state courts, a lot of the real important action I think is happening on the tribal side once the cases are there. So I'm really glad that we were able to talk about that, but also it was a crazy case in that, are we at the dawn of a whole new era of talking about plenary power? Are we witnessing this sort of a Gorsuch's unsigned concurrence against what Thomas has said that no one seems willing to get on board with? I mean, that struck me. None of the other justices were willing to sign on to what Thomas had said in the past or what Alito had foreshadowed in Adoptive Couple. So what do we make of that for sort of the future of Indian law? So it's been really wonderful to hear all of your thoughts on this. And I know no one can predict the future, but I'm at least comforted by some of what you all have said. So thank you for joining us. And thanks to my colleagues for co-moderating and having this panel. So, and I think there is going to be a transcript available. It's not live transcribing on YouTube. We won't give CLE credit for only watching the video later, but we are happy to give you a copy of the recording. And I think there's instructions in an email that you'll get from our school about how to access that. So again, thank you all for being here.
Thank you for putting this together and doing such expert moderating.
Yes, thank you.
Yes, thanks for the opportunity.